Good afternoon. Let me apologize in advance for the poor lighting I have here, but thank you for joining us for this discussion on the way forward on Supreme Court reform, debriefing the Presidential Commission report. I'm Russ Feingold, the president of the American Constitution Society, the country's foremost progressive legal network with more than 200 student and lawyer chapters across the nation. Now, ACS is celebrating its 20th year of shaping legal debate, nurturing the next generation of lawyers, judges, and advocates, and ensuring that the law is a force to improve the lives of all people. We've been focusing our work in this anniversary year on the legacy of our Constitution's founding failures when it comes to race and equality in this country. And you need not look any further than the United States Supreme Court to see a critical source of our challenges in this area today and going forward. As you likely know, in April, President Biden established a commission on the Supreme Court of the United States, tasked with, quote, providing an analysis of the principal arguments in the contemporary public debate for and against Supreme Court reform, including an appraisal of the merits and legality of particular reform proposals. I think we're awfully lucky to be in conversation today with two experts who can help us shed some light on the Commission's processes and the Commission's conclusions. The first is Kermit Kim Roosevelt, who served as a commissioner on the Presidential Commission on the Supreme Court of the United States. He is the David Berger Professor for the Administration of Justice at the University of Pennsylvania Carey School of Law. We are very pleased that he is our faculty advisor at the ACS student chapter there as well. He works in a diverse range of fields, focusing on constitutional law and conflict of laws, and has published scholarly books, including The Myth of Judicial Activism, Making Sense of Supreme Court Decisions, which sets out standards by which citizens can determine whether the Supreme Court is abusing its authority to interpret the Constitution. His new book, The Nation That Never Was, is a book that considers the period of the Civil War and Reconstruction more relevant to thinking of the values of our nation as opposed to the Revolution and the original Constitution. And Kim, if I have mischaracterized that, you will get a chance to fix it. He is a graduate of Yale Law School and served as a law clerk to Justice David Souter on the U.S. Supreme Court and Judge Stephen F. Williams on the D.C. Court of Appeals. Our other expert is Julie Chi-Hai-Suk, is a professor of law at Fordham University School of Law and an interdisciplinary and comparative legal scholar, researching equality at the intersection of law, history, sociology, and politics in the United States and globally. She has authored dozens of articles and books and chapters about comparative constitutional law, about the procedural implementation of equality norms in the United States and Europe, gender quotas, and women, work, and family. Julie received her doctorate in politics from Oxford University, where she held a Marshall Scholarship, and her JD from Yale Law School, where she studied in a Paul and Daisy Soros Fellowship for New Americans. Following law school, she clerked for Judge Harry T. Edwards of the U.S. Court of Appeals for the D.C. Circuit. Julie provided written testimony to the Presidential Commission on the Supreme Court of the United States. And Julie, I thoroughly enjoyed reading that testimony, which I thought was fascinating in terms of the comparative aspects that you brought out. So let's get into the discussion. Near the last 15 minutes, I will turn it over to Carey to help us with Q&A from the audience. But now we'll get into first some of the process and then some of the substance of what happened with the commission, and finally sort of where we should go from here. Let me start with Kim. For those not in the weeds, how would you characterize the central findings or the key takeaways from the report?
Well, I think that mainly what the report did was what the commission was charged with, which was looking at the leading proposals for reform and trying to state and not really assess the arguments on both sides. So court expansion was very prominent, term limits was very prominent. And then there were, I think, some less central considerations. We looked at transparency, we looked at the use of emergency orders or the shadow docket. We talked a little bit about cameras in the courtroom, code of ethics for the Supreme Court. But mostly, I would say what people focused on, and probably rightly so, is term limits and court expansion.
Julie, how did you find it? Same, is that anything else you wanted to mention as a key takeaway?
Well, I think that the report focused on court expansion and term limits, and particularly looking at the way that term limits might be achieved even without a constitutional amendment. But I thought that there were other materials that were quite interesting, including an appendix looking at the ways in which the confirmation process might be reformed, specifically the proposal, for example, to require a hearing and an up and down floor vote on every presidential nominee. So I think there was a range of ideas, and I think the report was very, even though it focused primarily on expansion and term limits, I think it did a good job of giving some account of some other proposals.
Well, for a lot of people, at least on the outside, maybe for those of you who are commissioners, the commission's charge was in many people's views sort of unduly limited and frustrating, and that it did not actually call for recommendations. Did either of you feel that this sort of hampered the inquiry? Let me start with Julie.
So, well, I think that if we just start with the problem to which the commission was a response, which is recent events, I would say, in the last 5 years, which changed the composition of the court very quickly, and is widely conceived to be a very conservative court that's out of step with what one might expect if presidential nominations, or just out of step with the way that the court has been composed in the past, and becoming much more politicized and partisan. And it would seem to me that instead of only focusing on the Supreme Court, focusing on the ecology in which the Supreme Court operates, so a wider range of institutions, including the Senate, that might be reformed so that the Supreme Court, the outcomes that we're seeing today would be different. So I think that in that sense, even thinking about the problem, which centers on the Supreme Court as a project primarily about Supreme Court reform, as opposed to the overall set of constitutional structures. I know that Kim recently argued in Time magazine that another problem with constitutional structure is the unforeseen evolution of political parties in American history. So I think that a charge that was broader ranging beyond reforming the Supreme Court itself towards the range of institutions and constitutional structures that have produced the place where we are today might have been more helpful.
Kim, would you elaborate on that issue with regard to the commission's charge, or any other concerns you might have about whether it was unduly limited?
Well, first, I would say I do agree with Julie that the problem is broader than the Supreme Court. So the way that things are in the country now, the way our political system is working, has to do with parts of the Constitution other than the Supreme Court and the Senate, the Electoral College. All of that needs attention. I think a commission that looked at the health of American democracy generally would be good. It would be a very different commission. It would require different procedures, I think, and a different body. With respect to the Supreme Court itself, the complaint that I've heard most often is you did all of this analysis, you set out all of these arguments, but you didn't tell us what we should do, right? And you didn't tell us which arguments are good and which arguments are bad. And I think that's a valid complaint, and I understand why people are frustrated, but I would encourage them to think of the report as just the first step in a process. So you could imagine two different kinds of commissions. One would be, we think there's a problem, we know we want to do something about it, and we'd like you to tell us what to do. And for that, you probably want a relatively small commission of experts who are mostly on the same page and are going to figure out the details of how you fix this problem. That's not what we had. And I can understand why President Biden didn't want that kind of commission, because maybe he wanted more flexibility to think about things going forward. Maybe he didn't know exactly how to proceed. So we had a different commission, which was a broad range of views, people from different sides of the spectrum, people with different institutional backgrounds. And there was no way that we were going to agree on recommendations. So if the charge to the commission that I was on had been to come out with recommendations, it would have exploded. And half the people would have resigned, or we wouldn't have been able to issue a report or something like that. So given who we had, the report that we wrote was really the only report we could write as a commission. But what I would encourage people to do is to think of this as, here is the first step. The commission has given you all of these perspectives, and now someone else, the American people or the Biden administration, has to decide which of these arguments is plausible, which makes sense, and what we should do going forward. So if this commission report is the end of the process, then yes, you should be frustrated. It was a bad job. If this commission report is the first step forward, then we can still believe that things will get better.
I find it interesting because we did complain as an organization, as many did, about the fact that there wouldn't be recommendations, but you make the point that it might not have been very pretty what would have come out of there. And, as I read the 2 key chapters, I realized that this really does help people access this issue potentially as a first step to really understand what are the range of possibilities. And, I'm certainly not going to praise the report in this regard in all respects, but at least it's accessible to people instead of being just a mishmash of a lot of different ideas that are never organized. So that's an interesting reaction. Kim, again, what can you share about the commission's process itself? We know that there were a number of points of disagreement. How were they approached? I understand that in addition, the 2 conservative commissioners actually resigned prior to the completion of the commission's work. How did the process sort of unfold?
Well, we were subdivided into working groups. So we had one working group basically for each chapter, which meant that different working groups were assigned different reform proposals. And then disagreements within the working groups, you could sort of hammer out in a back and forth, and people would say this argument should be included or this argument shouldn't be included. And there was a sort of normal give and take there. With respect to the broader commission, it was a little bit strange because all of our deliberations had to be public. So really, we did that during the public meetings. And we didn't have the normal sort of academic back and forth by email among commission members because we had to do all that in public. Overall, the way that disagreements got resolved really, I think, was that the co-chairs would return us to the principle that it's not our job to decide whether this argument is a good argument or not. It's just our job to put the arguments out there in the best form that we can. So generally, people who took particular positions would have the primary responsibility for drafting the arguments in support of those positions. And we just ended up with a lot of proponents will say this, critics will say this.
Julie, how did you find the process and the handling of the points of disagreement?
Well, I think the commission invited a wide range of people to testify. As far as I could tell, I think there were pretty broad-ranging hearings, including I was pleased to see that there were many scholars who focus on constitutional systems outside the United States, many comparativists, including a former justice of the Canadian Supreme Court, Rosie Abella. And so I think there was a range of ideas presented. And to some degree, you could see that not everyone who testified, and certainly the commissioners from their published work and even from some of the things that have been said and the op-eds that have been written afterwards, there are clearly disagreements. But I think, as Kim was saying earlier, the purpose of this exercise was really to lay out just the history and the range of options rather than to make a recommendation.
You gave testimony as many others did, Julie. Can you just take a minute to give us an overview, perhaps by category or constituency, of the views that were expressed during the process? Did Supreme Court practitioners weigh in, civil rights groups? Who were you who was the commission presented with?
Well, I think there are many law professors who focus on US constitutional law and constitutional history. And I think certainly there's a lot to grapple with regard to proposals to expand the court because of the history of FDR's court packing plan and just fears about the over politicization of the court and the court losing legitimacy. And I think there are just debates about the diagnosis of the current political moment as to whether the court has already been delegitimized. And I think that there was a range of scholars who brought in perspectives that we might not have had, including the possibility of a legislative override, which I think is more common in other constitutional systems outside the United States, constitutional systems that were designed in the 20th century rather than, or even in the 21st century rather than in the 18th century. I think that it was interesting also to see the perspectives. I think that many of the practitioners and advocates or people who are part of groups that have litigated before the court, it's predictable that I think that many of their perspectives are concerned more with the immediate moment and assessing the immediate moment that we're currently in. And I think that there was an interesting conversation in the report and in the hearings also about the extent to which the Constitution would have to be amended and the barriers that Article 5 would place politically to any proposals that would require constitutional amendment as a feasible option at this point.
So Kim, as a member of the commission, you've already alluded to this, that you folks weren't emailing to each other. Presumably you didn't have closed sessions with the group to discuss it. So did you find the public hearings meaningful? Were there any other opportunities to exchange your views other than just in those public settings?
There weren't really opportunities to exchange views across the working groups. So, each working group was really pretty much siloed, working on its own chapter. The co-chairs would sort of check in on the different working groups, and sometimes they would tell us, you're saying something here that's actually somewhat in tension with what another working group is saying, and we're going to have to work that out. But given the lack of access that we had to each other's drafts, the public meetings were actually quite important and informative. Because, first of all, we didn't know what the other working groups were going to say until we saw those drafts for the public meetings. And then we didn't know what the other commissioners thought either. So there's a tendency, of course, to think we're a group of reasonable people, and so everyone thinks like me. And understanding the range of views that was out there was actually quite valuable because, a lot of people spoke up during the public meetings and said things that I found very compelling. And it definitely affected the way that I thought about these issues.
So, as you said, different commissioners are responsible for drafting specific sections of the materials. In your view, was the division of labor good, the way it was set up, and perhaps the specific assignments, do you think it possibly influenced the report's findings, the way the labor was divided up?
Well, I think that the way that the labor was divided up among the working groups probably did influence the ultimate shape of the report. Since we didn't have particular recommendations, I don't think you could say that something, we went in a different direction. I think generally what the co-chairs did was to assign positions to people who were interested in the topic, and then have people who supported a particular argument be the ones putting forward that argument, which I think is probably the right way to do it, because that way you get what the supporter of the argument thinks is the best version of it. And you don't have someone who doesn't sympathize with the argument or maybe doesn't fully understand it trying to put it forward. So I think that was good. In terms of how the assignment to the working groups and the silo effect that we had because of the public accountability requirements, it's an unusual way to work, to have these different groups not seeing each other's work until the public meeting. But in the end, I think it worked out pretty well.
Fair enough. Well, that's a pretty good discussion then of the procedure. Let's turn you guys to the substance of this report. And Julie, I'll kick it off with you. What about the threshold matter of terminology? Court packing means one thing to some, and I know what it means to me, which is what the right has done to the court with a couple of recent confirmations. And I believe there were some complaints about the use of the term shadow docket, which the Supreme Court is using more and more often to decide consequential cases without oral arguments. Get your reaction as Julie, and then I'll ask Kim's reaction as a member of the commission.
Yeah, so court packing, I guess, is sometimes a term that's used by people who oppose expanding the court. But at this point, I think that the term has been embraced largely because I think increasingly those who favor expanding the court think that the court has already been packed. And so I think it's been kind of interesting to see the shift. And with regard to the shadow docket, I think that in general, it is something that's tied up with a much larger issue of how we control the Supreme Court's jurisdiction over a range of matters, whether we should be considering jurisdiction stripping or even mandatory jurisdiction over certain matters. So I don't know. I mean, I think shadow docket is an appropriate term because it is the part of the docket that most people, most Americans don't really think about or know about with regard, or when they hear cases that are coming out of the shadow docket, they don't realize that they're not briefed in the same way, or they're not, treated in the same way procedurally as the cases that they've granted cert on.
I mean, it's a relatively new term to have been coined in the not too distant past, and people are definitely beginning to figure out what it is. Kim, how problematic was the throwing around of these terms, court packing and shadow docket, on the commission?
Well, it wasn't a major source of disagreement. I mean, I think we should have expected that it would come up because people always like to describe circumstances in language that sort of tilts the field in their favor. And as Julie was saying, court packing sounds like a bad thing, and it's generally used by opponents. The commission ended up using the more neutral term court expansion. And then shadow docket. Shadow docket is interesting because it was coined recently, as you said, by Professor Will Bode, who is one of the conservative commissioners, and didn't intend it as a critical term. But I guess through the association of shadows and sinister things and doing things in secret, it did come to take on that connotation. And so some of the more conservative commissioners said we shouldn't say shadow docket because it makes it sound as though the Supreme Court is doing things in a sinister and underhanded way. And, we were trying to be neutral. So we also agreed with that, and we substituted emergency orders.
Slightly amused that calling something a shadow docket could not be predicted to have a negative implication, but so be it. Let's get to the major substance here, which is that, to the extent it can be said to favor any proposal, commentators have characterized this report as putting its thumb on the scale in support of term limits. So I'd like both of your views on why not term limits would be the answer to the problems the court currently suffers as you see them. Julie?
So I think term limits would be really helpful because the various forms of design that are covered in the report would just stabilize appointments so that each president would have a certain number and then the term limits. I mean, of course, it wouldn't go into effect until later. So I don't think it would solve the current crisis to the extent that people think that there is one. But I think the term limits would actually, over time, probably restore balance that's more reflective of what's actually going on politically in the country and what the people and voters' preferences. So I think, I think the real problem with term limits that comes up is whether this can really be done without amending the Constitution. I think there are some workarounds in the report that would involve Supreme Court justices rotating off and doing other judicial tasks, or even becoming a circuit judge or something like that. And my thought, this is discussed in the report, it would seem that those who oppose term limits, and there are many who do because they believe that term limits are necessary to protect judicial independence. And if you think, so I just think that the opponents would probably point to the problem of the office of the Supreme Court Justice being nominated and confirmed. And I think that if one is confirmed, it's the Supreme Court Justice office or position that one holds for good behavior. Certainly you can make that argument. And so I would think that it would be challenged. And I don't see term limits actually happening without a fair amount of controversy about amending the Constitution, one way or another.
We'll return to the Constitution versus statutory approach to that in a minute. But first, Kim, if you could give me your reaction on the term limits issue in general.
Thanks. Yeah, so I definitely do want to talk about the statute versus constitutional amendment issue. But in general, are term limits a solution to the problem that we're facing? Well, it depends on what you think the problem is. And in my view, there are really sort of three different problems, which require different solutions. And maybe some of them aren't even appropriate to try to address. But so one problem would be we just don't like the decisions that the court is issuing now. And term limits could resolve that eventually, because term limits will, over time, bring the Supreme Court more in line with dominant political opinion. It's a sort of slow and crude way to do it, maybe, but if there are particular decisions the Supreme Court is issuing that we are concerned about and we think they're out of touch with mainstream public opinion or constitutional consensus, then term limits will take us there eventually. Then there's the second problem, which is that the membership of the Supreme Court is being determined by random chance when there's an involuntary departure from the bench because of ill health or death. It's being determined by strategic behavior by the justices. So a justice will retire when a president of the same party as the president who appointed them can make the replacement. And it's being determined by partisan hardball. So how far are the parties willing to go in breaking prior norms surrounding the nomination and confirmation process? Denying a hearing to Merrick Garland was pretty extreme, but I think we can expect nothing but escalating partisan hardball. So the second problem, and this is what I think term limits really are the right response to, and I'm sort of astonished that there's opposition to them because it seems like such an obviously good idea. The second problem is that the composition of the Supreme Court is determined by these factors, which are not the factors we want. The composition of the Supreme Court should be tied, I think, to success in national elections, so that if you win the presidency, you have some impact on the Supreme Court. And the fact that it's not been done that way, and the fact that despite Democratic success in past presidential elections, we have a Republican majority now that could probably perpetuate itself indefinitely through strategic retirements, as long as Republicans win 1 out of every 3 or 1 out of every 4 presidential elections. This can go on forever. That's a problem, because I don't think that the Supreme Court should be a way in which a political minority can control the country on very important issues. And term limits indisputably will solve that problem. Again, not immediately, but eventually they'll bring us to a rational system, which I think is vastly preferable to the one that I have now. And then there's the immediate crisis, which is what's happening to our democracy. It's will we have fair elections going forward? And term limits will help with that, but again, they'll do it slowly. And I'm not sure that we have the luxury of time on that issue. I think that, it might be that if we don't act soon, we're not going to have fair elections going forward.
Well, the reflection of democracy point is critical, but I would just add that in terms of getting the public to be interested in this, I think the spectacle of what's happening with these justices probably bothers them like it bothers me, which is, this notion that Justice Ginsburg was quite ill and was hanging on in a way that does not look like the right thing to happen. The kind of thing that's happening now with Justice Breyer, with progressives saying, isn't it time to retire? These are pressures on people that seem like would not have been intended, not to mention the enormous expansion of life expectancy. since the founding of the country. When people say, "Hey, what about Oliver Wendell Holmes?" Okay, fine. He was on for a very long time, until he was 90 or something. But I think that all relates to the question of assuming for the moment that you have to have a constitutional amendment to do this. But we'll discuss that in a minute. But assuming that, what's the likelihood that that might go well? That the states, people might adopt it? I just want to get your gut reaction to a constitutional amendment.
So my guess is the odds are low, just because right now the status quo favors the Republicans, and anytime you have something with a partisan inflection, you're going to have partisan conflict over it, and I think it's very unlikely that Republicans would want to give up the advantage that they currently have, because like I said, with strategic retirements, they can maintain that more or less indefinitely.
Julie, how do you react to the possibility of that happening?
Yeah, I agree that I think that once you talk about needing a constitutional amendment, given that you need 2/3 of Congress, of both houses of Congress, and then 3/4 of the state legislatures, and I think that basically tilts Republican, or even if it doesn't, it's hard to imagine 2/3 of Congress agreeing to anything, and I think there's sufficient division about the composition of the Supreme Court. I mean, I think there's certainly a public debate about it, but I don't see 2/3 of Congress coming out in favor of amending the Constitution to impose term limits for the reasons Kim described. So I don't think that would be politically feasible.
Of course, the irony here is that the idea of these 18-year term limits was first proposed by conservatives, but we know the story on that. So then we need to go to the other question. What about, and Julie already alluded to this, what about instituting this by statute? You spoke a little bit about this already, Julie, but if you could expand, where do you come down on it? Good behavior and the appointments clause. You spoke a little bit about the Office of Justice of the Supreme Court. Does the Constitution allow for the implementation by statute of senior and junior justices? Julie?
So, I mean, I think it's not clear. I think certainly you can imagine some flexibility where the junior and senior justice proposal, at least at the circuit level, you have judges going senior, although they choose when they go senior, just as Supreme Court justices retire, and then they still do occupy certain judicial functions. So I think that I don't think it's a wrong reading of the Constitution to suggest that the junior and senior judge proposal is consistent with the text, but certainly I think that one might read the good behavior as meaning whatever office you get confirmed to, you get to keep for good behavior. And if that's the case, then you might see some litigation and other forms of contestation about it that would make it difficult to pass such legislation without it being invalidated.
Kim, you wanted to comment on the constitutionality or the need for a constitutional amendment versus the statute issue.
Yeah, I did, because this is one of the issues where my views actually sort of changed. Because I think if you look at it in the most straightforward, intuitive way, you would say, well, the point of term limits is to have people stop being judges. And the Constitution says the judges hold their offices during good behavior. So obviously you can't say after 18 years they stop being judges, consistent with that constitutional provision. And you can't. So my view is you cannot say we're removing you from office after 18 years. The key question, though, is what counts as removing a justice from office? And it turns out that under our current practice, under our current statutes, when a Supreme Court justice retires, they are still a justice of the Supreme Court. So David Souter is still an associate justice. If you read his resignation letter, he says, I'm retiring from active service pursuant to a statute that says, if you would like to retire from active service and retain the office, this is what you do. And his letter says, I'm retiring from active service. I intend to continue to render substantial service as an associate justice, which he still is. And it's pretty clear he is still at least some kind of judge because he's out there deciding cases. He's exercising the judicial power of the United States, which he couldn't do if he weren't a federal judge. Now, is he still a Supreme Court justice? I think he is, just because that's what the statute says, and that's what our practice is. And there's actually a Supreme Court case on this, featuring not a Supreme Court justice, but a lower court judge who took senior status, and then Congress tried to cut his pay. And one of the other constitutional provisions that protects judicial independence says your pay cannot be reduced while you hold the office. So here's this guy, he's taken senior status under the same statute that governs Supreme Court retirement. And Congress says, now we're cutting your pay because you've taken senior status, you're not really a judge anymore. And the Supreme Court says no. The Supreme Court says he retains the office. Congress has lightened his duties. They've changed the duties of the office, but he still holds that office. And it seems to me that the most straightforward analysis is that answers the question of whether the good behavior clause prohibits this. Because if you're not taking someone out of office, then you're not violating the good behavior clause. It's true that this is different in that what term limits proponents suggest isn't voluntary. It happens automatically after 18 years. But I don't see why that matters to the question of whether these judges still have the office. So if a retired Supreme Court justice is still a Supreme Court justice, still holds the office, I don't see why it matters to that analysis whether they take that position voluntarily or not. So I think at the least, like the straightforward argument based on our statutes and our practice is a justice who takes senior status still holds the office, no good behavior problem.
What would happen if Congress decided to add 2 seats to the Supreme Court, but that they were 18-year seats? In other words, they were temporary, that they would expire. Not that the person would lose their status, but it would simply expire. And go back and say, we're going back to 9 seats after 18 years. Would that be a way around this?
Well, that's an interesting question because there is general agreement that Congress has power over the size of the Supreme Court. So, I think maybe you could actually set up something that works that way, except that you can't really take people off by shrinking the court. There are a lot of interesting workarounds.
This one around for a while, and that's the best response I've gotten. So let's
yeah.
All right. Let me go to the other, of course, major subject, which is several commissioners have published op-eds in support of expanding the court and others in opposition to it. How do you respond to the op-ed by Commissioners Griffith and Levy that, quote, most of the reforms discussed in the commission's report have little merit and would threaten judicial independence? They also make the argument along the lines of Chief Justice Roberts' contention of a couple of years ago that federal judges don't identify with political parties or the president have appointed them. Do either of you buy that?
So I don't think that life tenure is necessary to judicial independence, but I think, and there are other valves other than life tenure that other systems use. I mean, you have non-renewable term limits and you put restrictions on the kinds of jobs people can have following their service as a Supreme Court justice. I think those are ways that you could protect judicial independence. I also think, and it's kind of interesting, the suggestion that judges don't identify with any particular political party. I think that's true for the most part, but I think over the last few years, there's been a lot of attention to the extent to which the Federalist Society, which is not a partisan organization, but is known to be a conservative legal organization, has been the source of Republican politicians, judicial nominees and candidates. And I think that dynamic is one that has caused some concern over the last several years.
Right. Kim?
So on the first question, would the reforms threaten judicial independence? Of course, it depends on what you think judicial independence is. My view is that the way the Constitution is supposed to work is you have individual justices or judges who are independent in individual cases, and their decisions are not influenced. But you have a judiciary whose composition over time is responsive to the popular will as manifested through presidential elections. And I don't think that you need life tenure for that. I think life tenure actually makes it harder. And as Julie was saying, if you take a comparative perspective, no one else does it this way. One of the witnesses, Tom Ginsburg, said, if we were writing the Constitution now, there's no way we would pick life tenure. Now, on the second question about whether judges identify with political parties or the president who appointed them, I think it's true that they don't. And you can see in the recent past some Trump-appointed judges ruling against Trump, because I think justices generally don't identify with the president as a person so much. And they probably don't identify with the political party as a party very much, although you do see some election-related decisions that seem to be favoring the Republican Party pretty consistently. But I think all of that is probably a product of the fact that people are different. People are different in their worldviews, and they're different in how they balance competing values against each other. And what that means is that judges are different, and judges acting in good faith will reach very different conclusions. So you don't have to say this is conscious partisan behavior, which is very extreme and maybe happens sometimes, but I think very rarely, in order to say it matters a whole lot who the judges are. And that's what these reforms are responding to, really, in my view.
Well, let's go to specifically now to adding seats. Commissioners Nancy Gertner and Professor Larry Tribe wrote that none of the reforms that have been proposed precisely fit the problem that needs remedying. And, I was really amazed to see the two of them come out specifically now and changing their mind, basically favoring favoring court expansion, moving to that, writing that, quote, this is a uniquely perilous moment that demands a unique response. I can't imagine when I was a student at the law school where Larry Tribe was the dominant constitutional law professor, either he or I or anybody else, thinking this was a good idea. But many of us at ACS have come around to it. And I think it's very interesting that during this process, these two folks wrote this. Where do you guys come down on? Julie?
Well, I think that the fundamental problem is that, as I was saying earlier, I think that the problems that led to where we are have much more to do with problems of constitutional structure. So we could add seats to the court, but if we don't do anything about the fact that the president nominates and only the Senate advises and consents, and therefore you have the Senate process that leads to the confirmations of these expanded seats, I don't know if it's, and again, it really comes to whether you see that the crisis we're in as outcomes being very conservative, or if you think it's a much larger problem with what Kim was saying earlier about presidents winning national elections and not necessarily having any judicial appointments, and other presidents because of unplanned departures from the court, having as many as 3 nominees to the court, and that being undemocratic and an imbalance over time with regard to the extent to which the court really reflects the mores and the evolution of our democratic politics. So, but to the extent that you think that you want a solution to either of these problems, it seems to me that the fundamental problem is that the Senate, as a matter of constitutional design, is extremely undemocratic and unrepresentative. And a lot has been said about this. The longest serving member of the House, John Dingell, proposed a couple of years ago that the Senate be abolished. And I wouldn't go quite so far right now, but certainly the point was that it overrepresents underpopulated states and underrepresents the more populated states. And so if you have the Senate and only the Senate voting on the confirmations, and so much power to the majority leader in the Senate and the Senate Judiciary Committee with regard to whether there will be hearings and whether there will be a floor vote at all. So I don't think that any proposal to expand the court is really much of a solution if these other problems of constitutional structure are not also attended to. And then there are other issues of structure, which I talked about in my own testimony, which we can get into. But I also think that in some ways, maybe making the court less political, the solution to the way to make it less political is to be more upfront about the fact that constitutional interpretation is complicated and that people are different and judges are different. And one way in which other systems do that is by making the confirmation process, but that by distributing it across a wider range of institutions. So you could have a system by which the House of Representatives confirms a certain number of candidates and the Senate confirms another certain number and the president gets a few. And you see that model in other countries. And also you can redesign the ways in which justices weigh in on constitutional questions through abstract review as opposed to deciding particular concrete cases. So I think that there are much larger questions. I guess I think that expanding the court would probably be better than not expanding it, but I do think you run up against the problem, which is that the appointments process and the constitutional structure have led in this direction that we're in.
Well, very insightful comments. Let me ask him possibly an unfair question since he was a commissioner. Let's say Commissioners Gertner and Tribe had been empowered to offer a motion to add seats to the court. How would you have come down on that?
I would support that. So, I agree with what they said in the op-ed that none of the reforms precisely fit the problem, because I agree with Julie that the problem is broader. I would say the problem is what Pam Carlin called the new counter-majoritarian difficulty, which is basically that it's possible for a minority to capture and retain every branch of the federal government. So you can win the presidency with a minority of the popular vote through the Electoral College. You can control the Senate while representing a significant minority of the population. And you can gerrymander to control the House with a minority too. And then what you see with the Supreme Court is basically what we see now, which is the president who loses the popular vote nominates justices, and they're confirmed by senators representing a minority of the American people. And now you've got the judiciary too. And what do we do about that? It's a big problem, and it has a bunch of different features in the Constitution. With respect to the Supreme Court, the only thing that can fix that now, and quickly, is expansion. And I wouldn't necessarily support that if I didn't think that there was also not a concerted attack on democracy going on. And that's the view that I came around to, and that's what has made me think that we need to act now while we still can.
All three of us have gone through that similar process. It's a slow realization what was going on. We're getting near the time for Q&A, but not yet. Julie, I want to go back to your broader comments because you're an expert in comparative constitutionalism. Your testimony was about other Supreme Court approaches where they resolve disputes over major social and political issues, even if it's not, I believe, in my reading, a case or controversy. With the oral argument in Dobbs, the challenge in Mississippi's post-15-week abortion ban, and the court's ruling in Texas SB 8 abortion ban, not far in our rearview window. Can you say and whether you think the commission's report has sufficiently considered alternative models?
Yeah, so I think that to the extent that alternative models were considered, because there was so much interest in term limits and court expansion as the primary reform proposals, I think that the comparative view focused on the number of justices and whether or not there were term limits and how they were structured in other systems. But I think it's really important to understand that constitutional courts, or courts that have the power to invalidate legislation, particularly invalidate legislation on a range of controversial social and political issues. I think in many other systems, it operates quite differently than from our own. And I think that if you think of a constitutional democracy and the different branches, the judicial branch and the legislative branch and the executive branch working together, you could imagine a healthy dialogue emerging. And part of this, I think, in the commission's report and in the hearings focused on the possibility of a legislative override. But what I focused on in my testimony was the existence of abstract review, that is, constitutional courts that actually review legislation before it goes into effect and before anyone has been injured by it. Because when someone has been injured, and of course, because of the case or controversy requirement in Article 3, you wouldn't have a court you couldn't have federal judicial power doing abstract review, and certainly the Supreme Court has said so in many opinions about standing, that there are no advisory opinions. But I actually think that the abstract review allows constitutional courts to look at a statute without the focal point being a particular injury, but thinking about it in relation to a whole range of constitutional arguments and values, and striking it down. And often you'll see that a lot of constitutional courts don't necessarily invalidate the statute immediately. Sometimes you'll see constitutional courts giving the legislature a chance to come back and rewrite the statute. And that is often what happens, where you end up reaching some kind of compromise. And a really good example is the evolution of abortion in Germany, where the legislature liberalized abortion by guaranteeing abortion on demand within the first trimester, I believe. And the Constitutional Court struck it down, saying it was insufficiently protective of unborn life on the one hand, but on the other hand, it went beyond and said, but of course there are some abortions that have to be constitutionally, that there is a constitutional right to have because of the dignity and freedom of personality of the woman. And the court went on to say, even though abortion on demand was not constitutionally permitted, certainly you would need protection for abortions that occurred because of the socioeconomic hardships that a woman faced in pregnancy. And so you get a wide-ranging abstract opinion like that, and the legislature went back, and even though they didn't have as liberal an abortion statute as they originally intended, they ended up writing a statute that permitted abortions in most circumstances where the sociological evidence that we look at today lead women to have abortions, including threats to not just life, but also health, including mental health and social and economic circumstances. And it was interesting to see in the Dobbs oral argument that Julie Rickleman argued, that is, there was a question that came up about abortion restrictions in other countries. And she pointed out that these are nominal restrictions because the way in which the legislature has written some of these laws really allows for abortion and funds the abortions that take place not on demand, but in most circumstances we imagine that lead women to choose. And so I think that's an example of a dialogue that took place because of the possibility of abstract review. And I think that that's one thing that we can consider and may even be able to consider in the United States without a constitutional amendment, particularly if you can think of a kind of hybrid, like a legislative court, even an Article 1 court, exercising abstract review over constitutional questions, reviewing statutes for constitutionality before a concrete case or controversy erupted. And indeed, that is what, I mean, the abortion fight, Texas, for example, the cleverness of the Texas statute is that they're trying to avoid judicial review by creating a situation when there's no state enforcement, no one would ever have standing to sue the state of Texas for the constitutional violation. But if you had abstract review, I think what most people want on all sides is some kind of pre-enforcement review of the statute. And so I think if we started thinking more imaginatively about institutions that we might actually be able to have outside of Article 3, that might be a way at looking at not necessarily reforming the Supreme Court itself, but changing the ecology in which constitutional interpretation occurs.
I commend to everybody your testimony on this really interesting subject. I don't want to cut out the questions, but I do want to ask one more. This will be a lightning round very quickly. I'm getting a more positive vibe about sort of the possibility of this commission laying the groundwork for reform efforts. Very quickly, each of you, what would you suggest pro-reformers do now? Kim?
Well, I think what we need to do is push our elected officials with the message that there must be a next step. So this commission report set out lots of different possibilities, and now is the time for political actors to weigh those options and decide what they want to do.
Yeah, Julie?
Well, as I've been saying, I think that the problem is with our constitutional structure, and the Supreme Court is one manifestation. So I think the president should have a much broader commission on constitutional democracy and constitutional reform, and study that.
Okay, very good. Kara, I hope I haven't cut it too short. I know you've got some good questions.
Well, I will try to put some of them together for you all. How about that? There were questions about whether specific reforms were addressed by the commission, or perhaps what your opinions are of them. So things like a supermajority vote for confirmation of justices, like a 2/3 requirement, perhaps, or age limit. I guess that would be a mandatory retirement age. And perhaps another proposal might be, if not those kinds of reforms, jurisdiction stripping.
I'll speak to that. So age limits, the term limits working group certainly did consider age limits, and generally we decided they weren't as good, because they'll give you a finite term, but they won't regularize appointments in the way that we thought was pretty important if you're trying to equalize the influence that presidents have on the court. Jurisdiction stripping, I'm not really a fan of. I mean, I do think there's a powerful case to be made that some of the problems that we have arise from the excessive role that the Supreme Court plays in the resolution of social debates. But I don't think that jurisdiction stripping is going to be a good way to fix that. For one thing, if you take jurisdiction away from the Supreme Court, there are still other courts out there. So you can strip from the lower federal courts too, but really that just means state courts are going to end up doing this. So I'm not sure that jurisdiction stripping is a good solution. And then what was the other one? Oh, supermajority Senate confirmation requirement. Yeah, I mean, honestly, I think the problem is that it's too hard to get a nominee confirmed, not that it's too easy. And one of the things that has to be stressed with term limits is it's not going to work unless you can ensure that each president gets 2 appointments. So that was one of the things that we really struggled with. It's fine to say the justices will come off the court at 18-year intervals, but if you can't get them on the court regularly, it's not achieving the goal.
Julie, did you want to weigh in on that?
Yeah, so I don't know if this counts as jurisdiction stripping, but I think to the extent that you can impose requirements on Supreme Court procedure, so that to invalidate a statute, you need 7 votes to invalidate an act of Congress, so I think that, or a requirement that invalidating an act of Congress, say in a facial challenge, would require that the statute is manifestly unconstitutional or clearly unconstitutional. I think I'd be in favor of those types of proposals.
Sure.
Okay, we've got 2 minutes and I'm going to ask you 2 questions, so maybe you can handle them quickly, although they're big ones. How should those in favor of reform answer the charge that our complaints are really about preferred outcomes and not underlying problems with the court itself that require institutional change? So in the words of Commissioner Griffith, that we wish to sacrifice the judiciary to partisan impulses. That's number one. And then the second one, just following up on the next steps question, there were specific suggestions of should there be a follow-up report or congressional hearings or perhaps executive action?
So for the first question, I think concern about specific substantive decisions is the weakest ground for reform. But I think that concern about the institutional relationship between the Supreme Court and the presidency or the national people is not about a particular decision. It's about the functioning of our constitutional system. And I would say concern about democracy and decisions that undermine the democratic process, that's not partisan. We are supposed to be a country where the people can elect the representatives of their choice and the government is responsive to the people. And trying to defend that is not a partisan position. And then on next steps, I would say, all of the above. Another commission would be good. Congressional hearings would be good. Executive action would be good. I just want to see something happen.
Julie?
So
You can
yeah,
have the final word, I guess,
agree.
Julie.
I think that there are much larger problems, and that's why I think the next step should be another commission looking more broadly at constitutional democracy, including but not limited to the Supreme Court.
Well, I wish we had more time. This really is an important conversation. And I want to thank both of you for joining us for this hour. The topic of Supreme Court reform is incredibly important to us at ACS and should be important to all Americans. And I think this is probably one of the first conversations in the country of this kind about the report and the steps forward. I'm glad we got them done in 2021 so people can really move seriously on this in the next year. If you want to learn more about it or us, you can find us online at acslaw.org. And I encourage you to follow us on social media. Good afternoon.
Thanks, everyone.